Good afternoon. I am Kaushiki Roy, Assistant Professor at IMT College of Law, Greater Noida. Today, I am here to discuss about the topic Divorce of Hindu Marriage Act 1955. Now, let's start with the topic. First, I will discuss about the concept of divorce. The word divorce had not been defined under any statutory provisions, but it could be defined as a legal dissolution of judicial ties established at marriages. Thus, a divorce is also a seven-letter word which separates the united couple at their own wish with their own consent. Thus, divorce can be considered a means to break marriage that happens not just between two individuals but also between two families. Now, I will discuss about uh, purpose of the law of divorce. Previously, as per the Indian culture and tradition, there was no concept of divorce which was considered to be existing. However, with the dynamic changes in the society, the very purpose of divorce is to punish the guilty party and also to protect the innocent or the loyal one tied within the matrimonial bonds. The very institution of marriage is to provide a happy coordinating partnership between two individuals. However, if this objective of marriage cannot be meted out, there is no point to continue the same. Therefore, for a happy, free, separate, and independent living who were previously tied within the matrimonial bonds, the concept and purpose of divorce arose. Now I will discuss about the grounds for divorce under the Hindu Marriage Act 1955. The grounds of divorce under the Hindu Marriage Act 1955 had been stated under Section 13 of the said Act. Thus, these grounds are lawfully valid grounds for divorce, and if such circumstances arises, then unfortunately divorce is bound to take place. The first ground is adultery. Adultery had been defined under Section 13, Clause 1, Subclause 1. It states that after solemnization of marriage, if a married person with the ties of marital bonds is having sexual intercourse with another person who is not his or her spouse is said to have committed adultery. Second ground is cruelty. Cruelty is simple terms means torturing or unreasonable brutal behavior against one. Thus, Section 13, Clause 1, Subclause 2 states that even after solemnization of marriage, treating the petitioner with cruelty can also be considered as a ground for divorce. Cruelty is also a criminal offense and also has statutory provisions for the same. Section 498A of the Indian Penal Code states about the cruelty by the husband or the relative of the husband on the woman or wife. This section clearly defines cruelty as any willful behavior which is of such a nature as is probably going to drive the lady to end her life or to cause grave injury to her life, limb, or well being, regardless of whether mental or physical, of the woman. Next ground is desertion. Desertion is, in simple terms, can also be considered as an act of abandoning a person. Thus, it has been defined under Section 10, Clause IB of the Hindu Marriage Act 1955. It states that divorce can happen if the person had been deserted by the respondent for a continuous period of 2 years immediately after preceding the presentation of the petition. Even if the spouse had left the home but still contacts the petitioner through emails or phone calls, it cannot be considered as a ground of divorce, or it could be stated that no desertion has taken place. However, if the respondent or the other spouse suddenly, without any reasonable cause, ceases to live with the petitioner or dismisses all the rights, obligations, and duties tied with the marital bond, then the essence of the only intention which he had was to desert the partner in the marriage. Thus, it could be a valid ground for divorce as well. Therefore, in the case of Ashok Kumar Arora versus Prem Arora, AIR 1987, it had been held that when one spouse separates himself, herself to bring cohabitation to an end, the other is entitled to seek for a decree of divorce. There is example of the second case, that is Jyoti Pai versus P.N. Pratap Kumar Rai, AIR 1987. It had been held that the initial burden of proving discontinuation from the society without reasonable cause lies on the petitioner. Next ground is conversion. Conversion as a ground for divorce had been defined under Section 13, Clause 1, Subclause B of the Hindu Marriage Act 1955. If one of the spouses within the matrimonial bond ceases to be a Hindu and converts into another religion, then the very essence of the Hindu Marriage Act gets destroyed, as a result of which it is considered as a lawful ground of divorce. Therefore, there had been such instances as well. There had been a case where the court held that a Hindu wife, upon conversion of Islam, may present Islam to her husband, and on the husband's failure to accept the same, the marriage would stand dissolved. Next ground for divorce is insanity. The word insanity had been derived from the word insane, which means not in a correct state of mind. Thus, a person who is not able to understand the difference between right or wrong, or who is unable to provide consent or to approve or disapprove the happenings around him, cannot be considered as competent enough to tie himself or herself within the matrimonial bonds. Insanity had been defined under Section 13, Clause 1, Subclause 3. Thus, the articulation mental disorder implies dysfunctional behavior, captured or deficient advancement of the brain, psychopathic confusion, or some other issues or incapacity of the brain, and incorporates. In the case of Ajit Rai Shiv Prasad Mehta versus Bai Basumati AIR 1969, it has been held that when the mode of matrimonial relief is unsoundness of mind, it must be proved beyond a reasonable doubt so as to satisfy the court in every possible way. Next ground for divorce is leprosy. Leprosy, otherwise called Hansen's ailment, is a chronic infectious disease brought about by the Mycobacterium leprae. The sickness essentially affects the skin, the pharynx nerves, muscular surfaces of the upper respiratory tract, and the eyes. Thus, it has been stated under Section 13, Clause 1, Subclause 4, that a person whose spouse is suffering from a deadly, infectious, incurable disease known as leprosy can sought a degree of divorce under this ground. In the case of Annapurna Devi versus Nabakishore Singh AIR 1965, it had been held even if it is not a disputed fact that the respondent is suffering from leprosy for 3 years or more immediately before filing the petition of divorce. The onus of proof lies on the petitioner to establish that leprosy is virulent and incurable. Next ground for divorce is vulnerable disease. Vulnerable disease, in some simple terms, is known as the sexually transmitted disease. Under Section 13, Clause 1, Subclause 5, it can also be a ground for divorce if one of the spouses is experiencing a serious incurable disease that is effectively transferable. A petition of divorce can be filed by the person. The explicitly transmitted illness like AIDS are accounted to be a vulnerable disease. It had been held in the case of Birendra Kumar versus Hemlata Viswas, where a wife is free from vulnerable disease, thus it is cruelty on the part of the husband to compel her to intercourse. Next ground for divorce is renunciation. A person may file a divorce under Section 13, Clause 1, Subclause 6, if one of the spouses renounces all the worldly affairs by embracing religion or any other belief. Thus, such a person attains a state of self-actualization as being defined by Maslow and wants to free himself from all worldly bonds, including from the bond of marriage. Thus, when the person himself, herself, does not want to take the responsibility of marriage, ties, relationship, and family, it could also be considered as a basic ground for divorce. Now, next ground for divorce is presumption of death. If an individual is not seen or heard alive by those who are required to normally know about the individual for a persistent time of 7 years, the individual is considered to be dead. The other spouse needs to file for divorce if she is keen on remarriage. Thus, such a situation is also a ground of divorce as being stated under Section 13, Clause 1, Subclause 7. In one of the cases, it had been held that there are near relatives assert that they had not heard of the husband for 7 years. The presumption of death under Section 108 of the Evidence Act should be drawn, can also be considered as a ground for divorce. Now, in this act also, wives have also some special ground of divorce. So now I will discuss about that. The wife also has some special rights, such as if the husband has one or more wives living at the same time. If the husband has one or more wives living at the initiation of this act, a wife may exhibit an appeal for divorce under Clause 1 of subsection 2 of Section 13 of the Act. Thus, constraint on the right of a wife who applies for divorce under this provision of that the other wife ought to be alive at the hour of presentation of the petition, independent of discoveries that the petitioner knew about the presence of the other wife and that the husband was not liable of cruelty. If the husband is guilty of rape, sodomy, and bestiality after the solemnization of marriage, under section 13, clause 2, subclause 2 of the Act of a wife entitled is for a petition of divorce on the ground of rape, sodomy, or bestiality submitted on her by the husband. Rape is additionally a criminal offence and characterized in section 375 of the Indian Penal Code. A man is said to commit rape when who had intercourse with a lady without wanting to, without her consent, or with her assent, which is obtained by placing her in dread of death or of hurt. Thus, when a wife gets to know that her husband did such an act, she has a special power to dissolve the marriage by letting him free. Sodomy is committed by an individual who has sexual intercourse with an individual from similar sex or with a creature or has non-coital carnal copulation with an individual from the contrary sex. Bestiality implies sexual association by a person against the request for nature with a creature. Now I will discuss about the irretrievable breakdown of the marriage. Here is some merits for that. If the individual tied within the matrimonial bond feels that the marriage is not working out, then mutually it may give the right to both of them to stay and live life separately and happily without any botheration on either part, as there is no reasonable probability of staying together. Thus, it gives both of them the opportunity to start their life as per their own wishes, independently and separately. There are also some demerits of the irretrievable breakdown of marriage. Irretrievable breakdown of the marriage may become an excuse where the married couple may always feel that little arguments are unreasonable, as a result of which there is no probability of them staying together. Therefore, in my opinion, the process of divorce following the irretrievable breakdown of marriage theory is not justified. It may also result from sudden, arbitrary, unreasonable decisions. If sometimes happens based on temporary emotions such as anger, humiliation, etc., which a couple may go through during the heat of the argument. It fosters no communication procedure between the partners. It is not just the breakdown of marriage, but it is also the wreckage of two united families at the time of marriage. If children are born out of that marriage, when the parents now think that there is no reasonable probability of staying together, such broken families could be a matter of stress for the child born out of the marriage as well. Now I will discuss about the procedure of divorce. Section 19 of the Hindu Marriage Act 1955 states about the court in which the petition of divorce should be presented. It also highlights the fact that every petition which is sought to have been presented under this Act should be presented to the district court within the local limits of the original ordinary civil jurisdiction. The petition can therefore be filed in the place where the marriage was solemnized. Second, the place where the respondent resides during filing of the petition. Third place is the place where the couple last resided together. Fourth one is the place where the wife of the petitioner last resided. Fifth is if the respondent is residing at a place which is outside territorial limits to which the act extends or not had been heard of being alive for a period of 7 years, then the petitioner could file a petition depending upon the places where he or she is presently residing. Section 20 states about the contents and verification of the petition. Section 20, subsection 1 states that every petition of divorce presented under the Hindu Marriage Act 1955 should be distinctly examined based on the nature and facts of the case, depending on which the claim of relief is decided. Section 20, subsection 2 states that the statement contained in every petition under this Act should be verified either by the petitioner or any other competent individual in a manner presented by the law for the verification of the plaints, and during hearing it may also be used as an evidence. Section 21A states that Clause A, subsection 1 of 21A states that where a petition under this Act has been exhibited to a district court having jurisdiction by the party involved with a marriage wanting for a decree for judicial separation as being stated under Section 10 or for a decree for divorce under Section 13. And another petition under this Act has been displayed from that point by the other party to a marriage praying for a decree of judicial separation under Section 10 or for a decree of divorce under Section 13 on any ground, regardless of whether in a similar district court or in an alternate or different district court in a similar state or in an alternate or different states. Section 21B states that firstly, the trial of a petition shall be taken in with the interest of justice, and it shall be taken day to day until the case is being concluded. Day to day, all the necessary reasons for filing the divorce petition should be recorded. Thus, it is stated in Section 21B, Clause 1. Secondly, an attempt should be made to conclude the case within a period of 6 months. Therefore, the cases are to be dealt expeditiously as being stated under Section 21B, Clause 2. Thirdly, in Section 21B, Clause 3, every appeal under the Act should be dealt as possible and should be tried to be concluded within the period of 3 months from the date on which notice of appeal has been served to the party. Now I will discuss about the theories of divorce. The theories of divorce. The first theory for divorce is the fault theory. The fault theory of divorce is also known as the offense theory or guilt theory. Therefore, it highlights on the point that a marriage can be dissolved when any of the parties within the bond of matrimonial ties commits an offense against the innocent party of the marriage. Thus, it is necessary to have a guilty partner and an innocent partner within the bond, the matrimonial ties. The innocent party only holds the right to seek remedy for divorce. However, the most striking feature is that if both parties are at fault, there is no remedy available for them. Next theory is mutual consent theory. The reasoning behind this theory is that since two people are marry each other through their free will, at the same time they ought to look likewise be permitted to move out willingly. In any case, it highly criticized that this methodology will advance immorality as it will prompt rushed separation and parties would break down their marriage regardless of whether there was a slight contradiction of personality. Next theory is irritable breakdown of marriage theory. The irritable breakdown of marriage theory is defined as a failure in the matrimonial relationship owing to such adverse circumstances that no reasonable probability remains for the spouses to stay together. As a result of such adverse, impossible conditions and situations, the husband and the wife cannot ever stay together. Thus, we can say that in such situation, the husband and the wife cannot ever stay together. Such cases, there is a stronger reason to live apart compared to the emotions of love, affection, and loyalty that should commonly prevail between the husband and the wife. Therefore, the rationale behind this theory is that if a marriage is beyond all possibilities of a repair, then it should be brought to an end. When a marriage is not able to last, then there is no point in sharing rights and obligations between the two parties. Why does divorce happen in society? A sociological perspective, the rate of divorce in Indian society has grown to a large extent. There are numbers of reasons for divorce, and the dynamic approach of the society at the same time could be witnessed regarding these stereotypical concepts of Indian society. There are some reasons for the divorce are as follows, like independence of Indian women in present scenario. Previously, women followed the norms of the given society without questioning about it, with their heads bowed down in front of the society for the sake of so-called family respect and status in the society. However, with the increasing modernization, industrialization, and urbanization, women started getting educated and also became more aware of their social happenings. Next reason is communication gap in marriages. Communication plays a very important role in marriages. Thus, when there is no proper communication between the two partners, misunderstanding and fights are bound to take place. Thus, lack of communication also sometimes become a reason for divorce. Next reason is cheating. Okay, thank you.